Thanks so much, guys. My name is Stephanie Lacambra. I'm the Criminal Defense Staff Attorney at the Electronic Frontier Foundation. I've seen many of your lovely faces at our table this week, so thank you so much for your support. I want to start with a caveat. This is not going to be the legal question hour, so I will not be answering your specific questions about your specific encounters with police. We will be talking on broad strokes about the various contexts in which people find themselves when they're confronted with this question about what to do when the cops demand their passwords. Everyone's individual threat model will be different, and so I want to respect that. So please just don't lose patience with me if I don't give you a direct answer about what works in your specific context. If you do have questions like that, feel free to email us at info@eff.org, and we'll try and connect you for a personalized consultation with a lawyer. Okay? So first things first, how do you respond to when cops demand your passwords? How do we get from here to here? Now, I will hopefully lead us along this journey, and you can kind of be equipped with some of the questions you should be asking yourself and the process for determining what you should do. So let's begin. Do I have to, this is probably the number one question I get asked when people find out I'm a criminal defense attorney. Do I have to give my passwords to the cops? Well, the answer is it's complicated. It depends on a couple of things. First, the jurisdiction in which you are in, and second, your personal threat model. So I'm going to geek out a little bit on law stuff for the next few minutes about various jurisdictions so that you can kind of see the landscape of how courts are dealing with this question and what they're doing. So, for example, in Colorado, a court actually ordered a defendant to give up her laptop password after the cops got a search warrant. So there was some legal process. And they actually, that opinion goes through what the court thought was necessary to have to make her do that. But at least there was some court order that happened before the cops were able to get it. The second is in Florida, the Florida Court of Appeal in 2nd District found that you can be forced to give up your password, but then the court, the appellate court, so the trial court level said, no, you don't have to give up your password. The appellate court reversed the trial court and decided to compel the person to give up their iPhone password. But the next level up, there are kind of 3 levels, the trial court level, the appellate court level, and then the U.S. Supreme Court. At the 11th Circuit, the federal appellate level, the 11th Circuit found that the government does have to show with reasonable particularity. What that means will also have to be fleshed out in further cases, but they have to make at least some showing that what they want, that they seek certain in a file or are aware that it's actually on the device that they're trying to get into. So if they have to be able to show that it exists in a specified location and identify what it is that they're looking for. Seems straightforward. Seems like before you get to go into a device, you should know what you're looking for and that it's there. But courts differ on what that reasoned particularity means. So in California, the Central District of California, which is also a federal appellate court, found that you can be compelled to give your fingerprint to unlock your cell phone, but not necessarily your password. And that seems to be a pattern that's been emerging in some of the other more liberal districts. In Virginia, the 2nd Judicial District, they found that you can't be compelled to give your passcode, but you can also be compelled to give your fingerprint. And they, again, using the same reasoning. In the law, we don't recognize a right to privacy in your physical appearance, which is why when you're dealing in a criminal case, the court can actually order the defendant to stand up, show how they appear, compel them to give a fingerprint. Now, the problem here is, and the argument that we make, is that your fingerprint really isn't about identifying you in this context. It's about providing information that the government wouldn't otherwise have. So you're actually not, it's not just about how you appear, it's about everything that you do as in the digital space, because it's really just a gateway to get at information that wouldn't otherwise be available to them without some help from you, which is why we think the Fifth Amendment is implicated. And I'll talk a little bit more about the Fifth Amendment later. So in Michigan, the U.S. District Court in Michigan held the same as both Virginia and California, that forcing someone to provide their passcode qualifies as testimony because it requires you to actually communicate in some way the knowledge that you have about your passcode. Whereas the fingerprints, you're not communicating knowledge. That seems to be the reasoning thus far. In the Eastern District of Pennsylvania, you can actually, there's a civil case, which was very interesting, that held that you could invoke your Fifth Amendment right to avoid testifying against yourself as a reason to not give up your passcode, even when it was an employer's phone. Here, I think it was like an insurance case, and they were trying to compel the employees to unlock their employer's phone to get at information that was relevant to the case. But because the passcode was a personal communication that was just in the employee's mind, they held that your password, because it's personal and producing it requires you to communicate, that you couldn't be compelled to do it. So that's a step in the right direction. And surprisingly, the Army Court of Criminal Appeals, I was surprised to find this, a military judge, so this is again at the trial level, upheld that the Fifth Amendment right to refuse to unlock your phone, it was sent up to the appellate level, the higher court, and they actually vacated the original court order that said you didn't have to provide your passcode, and said, well, we want further findings on your reasoning for why you are saying that the government can't get into the phone. You can't force this person to get into the phone. So it's now still being litigated. So we don't know, this is kind of a stay tuned. We don't know how that's going to come out. But they did affirm, eventually when it came up, they affirmed the judge's suppression ruling, which meant it threw out all of the information that was taken from the phone, but they did certify 3 issues for the appellate court to consider. One, whether the Fifth Amendment's self-incrimination clause, so for those of you that are unfamiliar with any cop show that ever, one of the first things they tell you is anything you say can and will be used against you in a court of law. You have the right to remain silent. When you are inside the United States as well, and we would argue even at the border, you have the right to remain silent and not cooperate in the government's prosecution or gathering of evidence against you. That's one of our fundamental constitutional rights. So here they're certifying that right protects you, and it is violated when. The question they're trying to answer is whether that right protects you when you voluntarily give your password to law enforcement under pressure. Well, I would argue under pressure. Government would say it wasn't under pressure, detaining you until you give up the goods. And then whether there's another case rule, whether it's violated when, like the Fifth Amendment is violated when investigators ask a suspect to give up their password when they've already invoked their rights to an attorney. Because generally when someone says, I want my lawyer, or I want to talk to a lawyer, they're supposed to cease questioning you. So the second question is whether if they ask you for your password after you've said, I want to talk to a lawyer, if that's violative of your constitutional rights. And then the third is whether they violated the Fifth Amendment, whether even if they did violate the Fifth Amendment, the military judge should have still kept the evidence in. So that's kind of, we'll see where that goes. The second thing you need to think about is your personal threat model. So I'm sure I'm talking to a bunch of people who are very concerned about information security. I'm sure you all know how to conduct your own threat model, but for those that are unfamiliar, the 5 main questions you want to be asking yourself are, what are your assets? What is it that you're trying to protect? Who are your adversaries? Who are you trying to protect those assets from? The capabilities. So what are your adversaries capable of doing to seize or interfere with your assets, the things that you want to protect? Your personal risk assessment. So this is kind of a balancing act between how likely is the scenario that your assets will be threatened by the capabilities of your adversaries, and what is your tolerance for that risk? How much risk are you willing to take on with protecting those assets? And then finally, the costs. How much trouble are you willing to go through to prevent those consequences, prevent those risks from coming to fruition and the adversaries getting to your assets? So this is the process. We always say in all of our surveillance self-defense trainings, to anyone that asks you, everyone has to come up with the answers to these questions to determine what makes sense and think about what tools to use in a particular scenario. Because, if you're an information security officer with top secret clearance, your threat model will be very different from, your high school teenager who is communicating with their friends on Facebook. Now, there might be some things that are common to both, but it's still a very different kind of thinking about what tools are at your disposal and how much risk you want to take on and the costs you're willing to pay. So let's start talking about some examples and to get people to volunteer some thoughts. I have some very nice EFF stickers that will be a reward to anyone that raises their hand and chooses to participate. And you will get to choose between various stickers. So the first being, let's start with the middle one. So meet the Guerreros. They're returning home from visiting their parents in Mexico when Customs and Border Patrol asks for their cell phone passwords. The wife is a U.S. citizen. Her husband is a legal permanent resident, and they have a small child with them and only have an hour before their connecting flight home. What are some of the things they should consider? All right, we have a hand over here. Wait. We have to pass the mic. We have to pass the mic. But since you'll be passing the mic, you will get to display and let people select the stickers.
One of the first things that I would consider is what I've told the customs officer and the messages on your phone. Because if there's a discrepancy with your story and any messages that you've been texting, for example, or emails, they can just refuse entry just based on the fact that you've lied to them.
Okay, so that is true. There are a number of things to take into consideration. One of them is the immigration status. Second is the law hasn't actually caught up yet with how the Fifth Amendment works at the border, because certain other constitutional rights have been suspended. For example, your right to be free from unreasonable search and seizure under the Fourth Amendment. They've decided, like the U.S. Supreme Court has decided that at the border, for limited purposes like enforcing the immigration laws and enforcing national security or protecting national security at the border, that they get to do suspicionless searches of travelers to make sure you're not bringing in a bomb. Now, Customs and Border Protection and the U.S. government is trying to use that argument that should also apply to other constitutional rights at the border. So it's a little more nuanced. But what I want to get at here is, what are those 5 questions that we should be asking for that threat modeling? What are some of the assets, adversaries, capabilities, risk assessment, and costs that this couple should be thinking about when they're deciding how to respond to CBP? And I think this gentleman in the back had his hand up first. But please, did you get your sticker? Yeah.
Well, you're going to want to look at your threat model and ask, are you actually defending anything in your phone that is so important that the opportunity cost of missing your flight, because you will miss your flight if you deny them, is going to be worth that? If there's nothing in there, you got your baby with you. You got an hour. Let it go.
So that is not an uncommon response, I think, to being presented with this kind of scenario at the border. And like I said, I think different people will respond to these questions differently in that situation. If you're a breastfeeding mother, you're going to be like, I have to be able to get to my feeding time with my kid. So one of the things when you're thinking about what assets you have, maybe before, and this is kind of going back, maybe before you actually get there, you think about, well, how are you going to, what are you actually going to take with you? Is there the digital information that you're carrying with you on your phone, on your laptop, how essential is it to this particular family trip? Do you want to leave kind of the more sensitive information at home to do like coming to a security conference, bringing your Chromebook instead of bringing your regular laptop? Those are considerations that you want to be thinking about before you hopefully get to that situation. And it looks like okay, yes.
Okay, so before they even begin to leave, they should decide whether or not if they are stopped by CBP and asked for their passwords, they should decide whether or not they want to bring their real phones, which have their entire digital life on them, or if they have throwaway phones, which have absolutely nothing on them, and you can be like, here, you can keep it because I'm not actually going to do anything with it when I get home. But if they had to bring their real phones, let's see, depending on whether or not they want to be split up, I'm not 100% certain on this, but I'm sure in almost every circumstance, a U.S. citizen cannot be denied entry into the United States. So if she's willing to leave her husband at the border or have him sent back, she could tell CBP to pound sand, take her kid back to their house, and figure it out later.
That is certainly another choice that the couple could make. And I know it's kind of hard because we started with this very difficult example. You are right that U.S. citizens have a right to repatriate themselves. They can't be denied entry. They can be seized for a certain period of time, and a reasonable time is all the guidance we get from the courts. Some cases they've found that 4 hours was reasonable, others that much longer was reasonable. So there's that. As a legal permanent resident, you also have the right to re-enter the United States, but it may raise some very difficult questions for your continued residency in the U.S. So that's something that people need to think about when they're deciding on their threat model. And then lastly, simple visa holders don't have a right to re-enter the country. Even if you had applied for and received a visa, if you come to the border and you refuse to cooperate with Border Patrol, they can revoke that discretion, because that's totally discretionary, your ability to enter. So there will be different threat models for those different classes of individuals. We had like one in the back, one over here, and one over here. So, yes.
So everything is based around the threat model.
Yes.
And so if you essentially just have the idea of privacy, let's just say, and you say, well, I'm traveling abroad, I'm going to bring myself a burner. No big deal, a Chromebook and a burner phone. Well, right there, they've opened up the phone, they see it's missing the apps, it's missing everything else. These are burners. Your threat model just went up. So simply by trying to become too disposable, you've just increased your threat model.
Yeah, so that is something that again, you do have to take into consideration when you're thinking about these tools that you're going to consider, or these options you're going to consider when you're traveling. We actually have released a pretty good border guide. I would encourage you all to log on to our site and look at it. It has there also a link to our one-pager on your constitutional rights at the border, as well as kind of what to do when you're before the border, at the border, and after the border. But yes, for the most part, when you're deciding how much security to undertake, one of the things we mention in our border guide is also be aware that if you take certain security precautions, that could also backfire and alert them if they choose to be looking at your devices. But one of the first things we recommend to people is, at the very least, shut everything off. log out of any apps that you have, so that even if you do end up giving your password, which is ultimately your decision, they still need an extra step to get through that digital portal into all of your other information on the cloud.
They can ask follow-ups, right? Facebooks and whatnot.
All right. So the question was, can they ask for follow-up passwords? Can they ask for your social media handle and password? So what's interesting about this is recently Senator Wyden actually wrote to the Department of Homeland Security and Customs and Border Protection and said, what is the authority that you are using to get into people's digital devices? And they wrote this very long letter back where they say, these are the reasons, this is where we think we get our authority. But they conceded that they will not be asking, at least in this letter that they've published in response to Senator Wyden, that they will not be asking for iCloud passwords that would go to cloud accounts, that it was just be for the devices that you're carrying with you, because they believe that it is within their power to look at and examine anything that you take with you across the border. I actually noticed a colleague's question in the back corner. And also this gentleman here. It's really hard. Since you're closer, we'll start here. Yes.
You mentioned that the court's still up in the air about exactly what rights a citizen has at the border versus in general. And it also was said that you have the right to repatriate as a citizen. But does that apply to your devices? In other words, they can say, you can go through, but your phone has to sit here until hell freezes over or whatever.
Well, so with the devices, yes, that's actually one of the responses in the letter, is that, they basically say, yes, you do have a right to enter after a reasonable amount of time, but we reserve the right to seize and search your property as it crosses the border. But even so far, this is just a policy, this is not law, but in Customs and Border Protection guidelines, they say that you should be, your property should be returned to you within 5 days. But that is subject to a very big loophole where if they have reason to believe there's some, the way they phrase it is evidence of crimes that in either immigration, fraud, or child porn is a big thing that they think they get to enforce at the border, that they can then hold your devices in order to do a digital search.
Also, I understand that they've asserted this diminished protection up to 100 miles inland from the border. And if you consider the perimeter of the United States, that's a huge amount of the entire population.
Oh, it's actually more. The courts have defined the border as 100 miles from the actual border inland. But in addition to that, any point of entry for international travel is considered part of the border. So it's beyond just the actual 100 miles around the whole U.S. It's any international port of entry. Okay.
So as of, I think it was Thursday last week, the U.S. border has said that all countries that fly into the U.S. Have to implement a law at the airports, or a rule at the airports, saying that all devices must be fully charged and turned on by the time you get to the customs gate. And so when I flew from Canada coming to here, I didn't have to submit my device, but I did see another Canadian who had to submit his device. And he was told, submit it or walk away and don't take this flight.
Wait, so, and he was forced to submit it powered on and unlocked?
Before we get to customs, we have to have it powered on. And he didn't say anything about locked, but it has to be fully charged and powered on. And customs has at that point the option to say, log in.
You're saying this is the point of entry at the U.S. border from Canada, or is this the Canadian government that's doing this?
No, this is U.S. Border Customs, or Customs has said that the airport that they're hosted in tell all of the passengers coming in that by the time they get to us, it has to be fully powered and turned on.
I was not aware of that.
Yeah, it's brand new.
Which airport was it?
We were flying out of Calgary.
Okay. That will be interesting to see how that unfolds. Because when we released the border guide in March, one of the general pieces of advice we were telling people were to shut off, power down everything so that it would require the entry of your passcode before they could get into it.
So the question I had for you, though, was as a Canadian citizen coming into the U.S., is there anything there do we have any wiggle room there? Because although I brought a burner phone, if this is identified as a burner phone, I can be rejected. But if I wanted to bring my personal phone, I have confidential information I'm not allowed to bring down here. So the alternative is really don't bring a phone?
Well, again, that you'll have to do, in that context, you'll have to revisit your threat model and determine for yourself, if this is the policy now being rolled out through the points through which you're going to be traveling, what are the assets you want to bring? And, how likely is it that you think you're going to get stopped? And how much are you willing to go through? Are you willing to say, no, I choose to keep my device powered off and just be prepared to wait? I mean, each individual is going to have to make that choice. I know we had a question the far back and then, okay. Shh. All right. I know he was trying to respond to something, but go ahead.
Yeah.
No, it's okay. It's okay. Okay.
I promise to pass the mic back to you in just a second. This might potentially implicate a response to the prior question, but so this will be 4 points. I'll collapse them into about a minute. So most police searches are executed in situations where police don't have constitutional authority, but individuals who are approached by authorities concede their rights. You waive your rights in response to a question by an officer, and that consent paves the way to any number of things. DHS component agencies are notorious for routinely violating limits on their powers. CBP is no exception. Despite the formal citizens' right to repatriate, I know of at least 3 cases of U.S. citizens who were denied reentry to the United States despite citizenship. And with respect to CBP's concession in writing to Senator Wyden that the agency does not have the right to seek social media identifiers and certainly not passwords, that's no reason to presume that CBP agents on the line will actually abide by that advice, which is why it's so important for each of you to be here and share what you've learned. The key to all this is asserting the rights that you know you have because you can't actually rely on the government to respect them.
It's well said.
So mine's more of a question.
Okay.
What's the justification if you bring a burner phone with you for them to say you're rejected from coming in? We've searched your stuff and found you to not be allowed to come in because you don't have anything. You're crossing with information that they found nothing really bad about you on, and they're saying, no, this is no good. We want you to bring the real stuff. And you're like, well, I'm not bringing that into the United States. I just have this. Why are you rejecting me? What's the justification there?
Well, that I don't know what their justification would be if they try to prevent entry. If you're a visa holder and they decide to prevent entry, that's always within their discretion. If you do have the right to re-enter and the border agent decides to follow the law and actually let you in, if ultimately the only red flag is that you brought a Chromebook and a device that's wiped of information, if they don't find anything, then they shouldn't have a justification for keeping you out. But that won't stop them from detaining you to find that out. So of course, we want to encourage everyone to be asserting the rights that they possess. We also understand that each individual has to make the choice about whether they're willing to forego, other conveniences like being able to make their connecting flight or, having to wait at the border while this inspection's being done.
I have a question or maybe a point of clarification. Some things that I'm hearing is this in communicating what's the questions about burner phones versus not burner phones. It just comes, for me, it's like, well, that sounds like over communication in terms of what we need to communicate to any legal authority. So I'm not even sure why we're making that distinction.
All right, is your question why do we care because they shouldn't be going into the device in the first place?
I mean, well, there's that, but then there's also if you allow them to go into your device, who cares whether it's a burner phone or not? Like, why are we actively communicating that it's a burner phone?
Well, the scenario that we explored earlier is that if the border agent is savvy, and again, like in the hierarchy of various law enforcement agencies, you're not dealing with a particularly sophisticated class of individuals at the border. I think that's the most tactful way to put it. But if they're able to discern from looking at the device that it is a burner phone because there's no information on it, that could raise a red flag, that could make your detention longer because they might be, looking a little bit further to see if they find anything. So I think that's the distinction between, burner phone, not burner phone that people are making. But then also just at base, what data do you really need to carry with you or have to carry with you? And are you willing to take the risks that anything that you have on you could, if you choose to, like, for example, if you choose to give the password, or even if you don't choose to give the password and they just detain the device until they're able to crack it, they will eventually get access to more information if you choose to bring your actual phone. Oh, okay. I'm so sorry to cut off the discussion, but I do want to get through some best practices. But we will definitely have more questions coming up. I just wanted to make sure everyone kind of goes through the galaxy or universe of what to be thinking about. So our EFF's position is that compelled decryption of your device is inherently testimonial and should be protected by the Fifth Amendment. So 4 steps that you can take for yourself is 1, don't consent to a search. This is the number one thing that Shahid was talking about. You have these rights, but if you give them up, if you waive them, if you allow yourself to cave under pressure to law enforcement, then they don't need a warrant. They don't need legal process. If you give them your permission, they get to go in. Number 2, ask to see a search warrant. And this applies as much, inside the U.S. Well, it's more inside the U.S. We'll see if anyone is like strong enough to demand it at the border. But ask to see a search warrant, and we'll go over what you should be looking for when you get to look at the search warrant. Choose to remain silent. This is also a choice, just like giving your password. You can choose not to provide any additional information for them to use against you. And then probably most importantly is ask to speak to a lawyer. If you have experiences, especially at the border, email borders@eff.org. We have lawyers standing by specifically on the issue of digital searches at the border. So let's go individually through each one. You can politely say no and tell the police and to come back with a warrant. It's easier in the United States. So we're going to take it in the United States context because I don't know that the courts would recognize this at the border. But you don't have to consent to a search or to give up your passwords. But if you do, they don't need a warrant. So that's first and foremost. We're going to skip the other examples and go to. So when you ask to see a warrant, if the police say they have a search warrant, you should ask to look at it, and especially if they and this is something we usually tell people that we think might be targeted at home. If they come to your home, you don't actually have to answer the door. You can ask them to identify themselves and slip the search warrant under the door. You don't actually have to give them admittance into your home, and very few people know that. But check the warrant to make sure it actually lists your name, that it lists your correct address, because a lot of times the information's wrong, that it actually lists the items and devices to be searched, the accounts to be searched. If it does in fact allow them to get into your digital accounts, and that it specifically orders the disclosure of passwords. If they're trying to say, oh, we have a search warrant, it says you have to give us your passwords, make sure that's actually part of the warrant. And then the asterisk is I don't think that would be a lawful order, me personally. I don't think that you could be ordered to give up your constitutional rights. So if you are particularly hardy and scrappy and are willing to forego, you could be held in contempt. So if there are some people that believe in this principle enough that they're willing to say, yeah, I'm willing to do that. There are even big companies that when they're asked for user information and they're trying to say, hey, we have a search warrant for this and we want you to give it to us, who will say, well, we're just not going to produce those records and we'll fight it as a contempt order. We'll go to the judge. The judge can try and order us, and we'll fight that whether or not this is a lawful order before we even give you the records. So this is, again, a choice. We can't tell you that that's something that everyone should do because everyone's threat model will be different, but that is definitely something that you should be thinking about. And then lastly, to check to see that it was actually signed by a judge. A lot of times they try and pass off subpoenas that are just signed by like an attorney or like a prosecutor or a policeman who it's just like an affidavit. Make sure that it's actually signed by a judge, Judge so-and-so, the Honorable so-and-so. Now, whether or not you have time to check if that's in fact a real judge, I mean, it just depends on how skeptical you are. And then don't interfere with the search if they have a search warrant, because that could be considered obstruction of justice, which is a separate crime. But do object if the cops try to go beyond the areas that are identified in the warrant. So those are kind of our quick and dirty things to think about, and we're going to skip the other example. And you can stay silent, so you don't have to say a word to the police to help in the search if they do end up serving a search warrant. We believe that you shouldn't have to give your encryption keys or passwords to the police. The exception being that there are some courts that think that they have the right to compel you to do so. So usually it requires that extra step of getting a court to order you to divulge that information. And again, we believe that courts shouldn't be able to do that, but you're going to have to make the choice of whether or not you're willing to deal with the contempt punishment while you litigate that. And if you decide to talk to the police, tell the truth. Don't go like, oh, I forgot my password. Oh, this isn't my device, because lying to the cops is a crime. So please don't do that. And once the police are searching your home or computer, again, don't interfere or obstruct, because it's a separate crime that you can be charged for. I'm just going to go through the last thing, and then we should be able to open it up to questions Oh, okay. Okay, I just wanted to make sure we got through the meat and potatoes of what we're trying to disseminate. If the police want to search your electronic accounts or devices, or even just to talk to you, you should talk to a lawyer beforehand if you have that luxury, if you have that opportunity. We recommend, if you really think you're going to be targeted at the border or at a particular point, to try and consult with an attorney beforehand to see what other steps you might be able to take to protect yourself. A lawyer can also help deal with getting your devices back and getting a court to order destruction of any data that was seized if, in fact, they ended up going into your devices. Okay. These are kind of these are the basis for why EFF has come to this position on why decryption is testimonial and passwords are testimonial. The Fifth Amendment privilege against compelling you to testify against yourself should protect testimonial statements. That's like the basis of the Fifth Amendment. We believe that testimonial communications and this is also reflected in the law, are those that require a person to use the contents of their own mind and to communicate some kind of fact. Seems pretty cut and dry in that context that a password would force a person to reveal the contents of their mind to law enforcement, and so thus should be privileged by the Fifth Amendment. And that is the argument that we're trying to advance in the courts, and are always looking for people that are willing to help us advance that argument. But the process of decryption itself, if you think about it, it is testimonial because it involves translating all of this encrypted data into new data and communicates it to law enforcement in a way that they can read it. And so again, they only get to that unencrypted data through the contents of your mind. So this is kind of our quick and dirty rubric for why we've come to this position. So hopefully we've gotten there to what are the things that you can be doing, but you understanding what the threats are and risks are. And if we have questions, yes.
So just to point something out when you're thinking about your threat model, your employer, well, to give an example, I recently did some overseas travel and I had to check with my employer beforehand about the policy of potential seizure. And I was basically told, don't give them passwords. If they seize the property, they seize the property. If they do anything, if they detain you in any way, contact our lawyers, and our lawyers will defend you. So my company's stance, at least, and yours may be the same, so please check. Have your legal department draft something if they don't already have a stance on this. But the idea that basically my company is saying, no, we're not going to let that, that pass. Our IP is our IP, and exposing it unintentionally or intentionally that way is not acceptable.
Well, that's a very strong stance, and I applaud your company for doing that. Yeah, we should applaud that. Yeah, do we have another question?
Okay, I have a question.
Oh.
If a non-U.S. citizen is denied entry into the U.S., is that final? Like every time they try to enter the U.S., next time they'll say, I see you've been refused, we're refusing again.
Well, that depends. If we're talking about a visa holder, they'll have to consult an attorney to see if there's a process for review of the denial of entry, and then they'll have to go through the process of reapplying for entry. And they'll probably come across the same issue because if they've been denied entry already for that reason, it's likely that when they reapply, they will try and do the same thing. If you're a legal permanent resident, you can defer litigation of your continued residency in the United States. So you can defer the decision to the immigration court. That's something that your lawyer can ask for. Hopefully you have consulted one before crossing borders if you're in that position.
You mentioned before that you don't have to open your door for the police, even if they have a search warrant. You can have them slip it under the door. After you verify the information on that search warrant, do you have to now open the door to them?
Yes,
okay.
You would be obligated, and you could make the choice not to, and then they will likely break into your home. And sometimes, even before you're done reading the warrant, they will break into your home. So. And that is still something I don't want to give it short thrift. You can litigate that after the fact, but there won't be a judge on call at that moment to say, hey, you shouldn't have done that.
Do you want me to?
Yes.
Okay, just to clarify a point from the map at the beginning, in places where they can compel you to give up your fingerprint but not your passcode. I turn off Touch ID on my iPhone. Can they compel me to enable a Touch ID on my iPhone?
That specific issue hasn't been litigated. I think that because it would require you to do an affirmative thing that wasn't there before, that it would be more difficult for them to be able to do that. But only time will tell. Like, we have to actually wait for it to come out in the courts. That's not to say also, and I've been corrected about this because I don't use Touch ID, but there are people that use both Touch ID and an alphanumeric password. We just recommend not to use Touch ID by itself. If you use it in conjunction with a passcode, that could still be more secure for you. So it just kind of depends.
In 2013, the State Department website said that when you were leaving the United States, even as a U.S. citizen, they basically viewed encrypted data as kind of suspicious. Therefore, they reserve the right to copy it and keep that copy forever. I'd heard the rumor they've tuned that back to 5 years. Where's the stance from the EFF on that now, and what's the law?
On compelling production of encrypted data?
Well, no, them copying my encrypted data and keeping it forever. If I they were basically saying, if you have encrypted data, we have the right to copy it and keep it forever.
The State Department does that as a result of your applying for a job with them, or
No, just crossing the border, just like going to Canada.
Yeah, our position would be that there's got to be a policy in place about data retention. They shouldn't be allowed to keep your data forever. But they shouldn't even be allowed to get to your data if they don't have the authority to do so. So that is our position. Whether or not I have yet to we've only so far come across cases where they've kept the data for a limited amount of time, but you actually have to affirmatively request a court to have them purge the data.
Quick follow-up on that. If they took my data, and I've got 3 laptops, and one of them's for malware research, and they get malware from that, is that me attacking the government?
So remember what I said about specific questions? If you want specific answers, email info@eff.org.
Okay, so quick note on restricting the amount of, if they have come into your home, there's the principle of plain sight. Anything that's in plain sight to a police officer is potential evidence. You cannot restrict them from that. That was it.
Okay, yes, that is true. Once the law enforcement does gain entry, whether it's to your home or to your digital device, they are trying to use the plain view doctrine. I think it survives within the home if they have a legal right to be where they are to make the observation. In the digital space, this is why ex-ante protocols, search protocols, should be determined by the judge before they get to go in, and that's something that we're fighting for. But I don't think that the plain view doctrine should apply in the same way in the digital space, because you can't be like, well, but let me look at everything because I'm looking for the specific thing. I don't think that theory translates in the digital world.
Stephanie, a moment ago you said that you were always looking for people that would help advance your Fifth Amendment argument. Other than joining the EFF, which I think everybody in this room should do if they're not already, what specifically are you looking for there? Can you expand on that a little bit?
Well, if someone decided to be a test case and wanted to stand up to law enforcement at the border or otherwise, we would be interested in being a part of that. So please, if that is something that you're interested in, contact info@EFF and we will talk about it.
Yeah, hi. I just had a quick.
Where?
Right here.
Oh, okay.
I just had a quick something to say. I got this from Kevin Mitnick's book, Art of Deception. What he does is whenever he travels, he takes out his hard drive, and this is very easy to do with solid-state hard drives, puts in another hard drive and just mails his, or UPS's, FedEx's, his other hard drive to where he's going to be. So that's just an easy workaround for this type of situation. Just wanted to say that.
Okay, that is certainly there are a number of practices that people adopt to try and get around it. It will present different risks depending on, if you're going to be mailing that to China or Russia, that might not be the best way to get around the American government. But you got to have to deal with your individual threat model. Okay.
Back here. Hi. So in regards to, because we were talking about burner phones earlier, so in regards to burner phones, would the fact that there is a lack of information on there, could that be regarded as
suspicious?
The right to remain silent if you choose not to put any information on there?
Well, so sadly, the state of the law with the Fifth Amendment is you actually have to assert it. They've already, the Supreme Court has already held that remaining silent is not enough to invoke your right to remain silent. You must say, I wish to remain silent, before they will recognize the right. So just, for example, using a burner phone you could make the argument that that is a way in which you were trying to assert that right, but you actually have to affirmatively assert it for the courts to recognize it.
We've got time for 2 more questions, including this one, right? And then afterwards, we still have time in the room. So a little bit, but I need to start getting things. I'm really sorry. But don't come at me later on. Go on. Right.
Sure. So regarding the subpoena before, you talked about a search warrant signed by a judge. Subpoena could be signed by just an attorney. If they show up at your house with a subpoena, it's not signed by a judge. Can you just reject them from entering your house and say, come back with a search warrant, I'm calling my lawyer, sort of thing?
So again, it depends on what the subpoena is asking for. Specifically, if the subpoena is asking for getting into content in your digital device, the Supreme Court has held even being able to search your cell phone generally should require a warrant under a case called Riley versus California. So I think there is precedent for you to be able to say, if they're trying to get to content with the subpoena, that you can reject that. I would encourage you to consult an attorney before responding to the subpoena, because most subpoenas have to give you a reasonable amount of time to respond. So usually it's 5 to 7 days. Some are 10. Some are even longer than that. So prior to the date of that you're required to respond, I would seek the counsel of an attorney to determine how you want to handle that, because it will depend on what the subpoena is demanding and on what time frame they're demanding it. And our last question.
Hopefully this is an easy one. Cops come to my house. I request to see their search warrant. They show me the warrant. Are they required to either provide me a copy or allow me to copy that warrant?
So they are not required to provide you a copy. There is nothing that would prevent you from taking a picture of the warrant with your phone. More prudent people would ask before reaching for a phone to do that. I'm personally more a person that asks for forgiveness than permission, but I'm not a particularly threatening specimen. I mean, so it just depends. But yes, you should be given the opportunity to get a copy of the search warrant. They will usually tell you, oh, well, we'll send it to you. I don't trust cops generally, so I would try and do everything that I could to get a copy. And so we will stay in this room. I will answer more questions. Thank you so much for being so participatory.